Good morning, everyone. My name is Arpan Banerjee. I'm a doctoral fellow at the Department of East Asian Studies, University of Delhi, and academic counselor at IGNOU. And I've been teaching you the paper BPAC 133, Administrative System at the Union level. And in this paper, we have, so welcome you all to my learning session. And in this paper, I have so far covered block 1, which dealt with the evolution of Indian administration, in which I have discussed the unit 1 dealing with ancient administrative system. After that, we discussed the administrative system as part of unit 2, unit 5A, that is legislature, and unit 5B, that is executive. So today we are going to finish this second block, and we are going to discuss unit 5C, that is judiciary. So let us begin today's lesson. As we all know, it is the institution for delivering justice to the people and the government, and it occupies a very significant position in the three organs of the state. Of the state we have already discussed: executive, legislature, and judiciary, out of which judiciary also occupies a very significant position. In our country, our constitution has stipulated, has entrusted the responsibility of being the custodian of the constitution to the judiciary. So our judiciary, or the Supreme Court, is the custodian of our Indian constitution. Hence, judiciary plays a very important role, and it is considered a logical requirement of any society. And because human nature itself, it expects justice, and human nature itself is intolerant to injustice. Hence, judiciary, it stems from the human nature itself, we can say. The human tendency to always advocate justice and being intolerant towards justice. So, judiciary basically enjoins upon all of us a responsibility, basic order in the society. So, basic order in the society has to be preserved, and judiciary, it ensures that this order is preserved. And if it is not, if people are violating the norms, the rules and regulations, then of course to penalize those people. So that is the general function of the judiciary. In India, we have an integrated judicial system. So in India, it has authority over all the courts, whether it is a high court, whether it is a district court, whether it is a family court, in any corner of the country, and it has got the authority to do. So its jurisdiction is throughout the territory of India. However, if we see in countries like United States of America, they do not have an integrated judicial system. In the United States of America, if you see, the Supreme Court there, it has authority, it has jurisdiction only in terms of federal matters, subject which fall in the federal list or the union list, or only in cases of conflict between the center and the states, right, between the union government and the provincial government in United States. So in case of criminal matters, the Supreme Court of United States is not concerned. It is the courts of the states or the provinces that are in case of criminal matters. However, in India, if we see, in all matters, whether it is civil matters, whether it is criminal matters, the Supreme Court is the highest court of law. All right. So it has it has appellate jurisdiction, it has criminal jurisdiction, it has civil jurisdiction. So it has jurisdiction across the entire territory of India. Hence, we can say that we have an integrated judiciary. And also, the judiciary has the power to punish for its contempt. So Article 129 gives the Supreme Court the power to punish people for the contempt of the Supreme Court, and Article 215 gives power its contempt. And also the Supreme Court has been entrusted the responsibility to do complete constitution, and all civil and judicial authorities are required to aid the Supreme Court in doing complete justice. Article 144 stipulates this, and Article 142 says to complete justice. All right, and for doing that, it can order any person or any evidence to be produced before. The Constitution gives the Supreme Court the responsibility and the authority to do complete justice across, and also it tells all the civil and judicial cooperate with the Supreme Court in order to enable it to do complete justice. And also, India can also seek advice of the Supreme Court in certain matters. 3 stipulates this. The President of India can also seek advice of the Supreme Court in certain matters. And if we Government of India Act 1935, it for the first time created the Federal Court of India, which is now called the Supreme Court. And it was at that time before independence. However, the highest court of appeal was the Privy Council of the King. So, however, in today's India, the highest court of appeal is also the Supreme Court. After independence, the Privy Council was done away with, and the Supreme Court became the highest court of appeal. And the Constitution of India, it contains a number of provisions and articles which clearly stipulate the structure, functions, and powers of the judiciary, both at the union level and at the provincial level. And the Constitution of India has introduced an integrated judicial system for the entire country. And in our country, we have a 3-tier judicial system. So the Supreme Court is the highest court of the land and the highest court of appeal, followed by the high courts, which are the highest courts in the states and union territories. And also beneath the high courts, we have the subordinate courts in every state and union territories. However, the Constitution of India, it only contains provisions related to the Supreme Court and the High Courts. And the provisions regarding the subordinate judiciary is not there in the Constitution. It is left to the jurisdiction of the states, the state governments. So the Constitution of India, it contains provisions related only to the Supreme Court and the High Courts, and not related to the subordinate or the courts beneath the High Courts. That the provisions regarding the subordinate courts have been left to the states. So India has a 3-tier judicial system: Supreme Court, High Court, and subordinate courts. However, we have a unified judicial system, and the Supreme Court of India is the highest court of appeal. It has jurisdiction throughout the territory of India in all matters, whether it is criminal. It also has appellate jurisdiction, and the Constitution of India has also given has also placed the responsibility on the Supreme Court to protect the fundamental rights of the citizen. So Article 32 of the Constitution of India, which has been described as the heart of the Constitution by Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constitution of India, and also India's first law minister. So Dr. B.R. Ambedkar, he described Article 32, which is which he has described as the heart of the Indian Constitution. So the Article 32, which basically is related to right to constitutional remedies. So if a citizen's fundamental rights are violated in India, then he can directly approach the Supreme Court. He or she can directly approach the Supreme Court, or the Supreme Court itself can take cognizance of that violation of fundamental rights. And now, after the introduction of the public interest litigation, any person can file a petition on behalf of those whose fundamental rights are being violated. So it is not necessary fundamental rights are being violated, or a group of persons whose fundamental rights are being violated. Only they have to go and file a case in the Supreme Court. It may be possible fundamental rights are being violated and who are being exploited, they may not be aware of that because of various reasons, because of socioeconomic problems. They may not be able to contact the Supreme Court. So any public spirited individual can file a petition in the Supreme Court on behalf of those people whose fundamental rights are being violated. So the concept of public interest litigation is also there, and since the case of Roshanara Khatun versus State of Bihar, in which a petition was filed regarding the poor condition of under trials in the jails of Bihar. So the concept of has started, which further got strengthened by the MC Mehta versus Union of India case in 1986, wherein the Supreme Court it in a way enlarged the jurisdiction, the definition of Article 21 and also of Article 12 as well. So regarding environmental legislation, the Supreme Court stepped in and showed judicial activism. The Supreme Court has been entrusted with the responsibility to protect the fundamental rights of the citizens. Article 32 of the Constitution, it gives the citizens of India the right to approach the Supreme Court directly in order to protect their fundamental rights. And and not only after the fundamental rights have been violated, it is even before the fundamental rights have been violated, the Supreme Court can step in order to prevent the fundamental rights of citizens from being violated. The Supreme judgment in MC Mehta versus Union of India 1986 clearly stipulated it. Only after the violation of rights, rather it is also before the violation of rights that the Supreme Court can intervene and prevent the violation of the fundamental rights of citizens. So it entrusts the responsibility of protecting fundamental rights of the citizens on the Honorable Supreme Court, and it also gives certain writ jurisdictions upon the Supreme Court, which we will discuss. So Supreme Court, if you see, it is the Constitution. It envisions an independent, unbiased, and able judiciary. So that is why the Supreme Court of India, it has been kept independent. The judiciary, not only the Supreme Court but also the high courts and the subordinate courts, the judiciary itself has been kept independent from the executive. So the Supreme Court and the high courts, the judges in these courts, they are selected by the collegium. And there is a collegium which selects and recommends names to the Chief Justice of India, and the Chief Justice then gives the suggestion to the President of India. So this system, it came into being after the emergency. So before the emergency, before 1975, the central government, it played a huge role in appointing judges, and based on its recommendations, the president would give names. However, after the emergency in 1975, when the fundamental and the Supreme Court was not able to protect it, the Supreme Court came under a lot of criticism. After the emergency, the Supreme Court, it showed a lot of judicial activism, and in succeeding cases, in the first judges, second judges, third judges, and the fourth judges cases, the Supreme Court laid down the procedure for appointment of judges, whereby the Chief Justice is required to consult senior most judges of the collegium, names to the president for appointment in the high courts and in the Supreme Court as judges. So the president cannot appoint judges on the president of India cannot appoint judges in high courts and Supreme Court her own based on her own discretion. India has to abide by the advice that has been rendered to her by the Chief Justice of the Supreme Court of India, and the Chief Justice also, in rendering that advice, cannot exercise her own his or her own discretion. The Chief Justice of India also has to consult the collegium or the senior most judges of the Supreme Court, and after consulting them only, the Chief Justice of India will be able to give an advice to the President of India, laid down by the Supreme Court of India in successive cases. So that is why, if you see, the Supreme Court of India, in terms of appointments and in terms of its functioning as well, is independent, and because it's and not by the executive or the legislature. If you see, in countries like United States of America, the president appoints judges to the Supreme Court of the United States of America, and those judges who are appointed to the Supreme Court of USA, they are there for lifetime. So their term does not expire as long as they don't resign, or they do not, as long as they are alive, they remain the judges in the Supreme Court of United States of America. However, in our country, the Constitution, it clearly stipulates that a judge of the Supreme Court, can remain at his or her post only till the age of 65. So once a judge of the Supreme Court crosses the age of 65, he has to retire. And in the case of High Courts, it is 62 years. Of the High Court, only till the age of 62. Of Supreme Courts, it is 65 years. So appointment of judges in our country is done by collegiums and not by the executive or the legislature. And there is also a security of tenure as well. That is, the judges can stay in office till the age of 65 in the case of Supreme Court, and 62 in the case of High Courts that I have just discussed. And the Supreme Court judges are also prohibited from practicing law before any court of law after retirement. So they can be, after retirement, they can be called in as acting judges or as ad hoc judges. The Constitution stipulates that, but they cannot go a court of law after retirement, the Supreme Court judges. And the payment of their salaries and allowances and privileges are also stipulated in the Constitution. And the actions and decisions of the judges in their official capacity are also immune from any judgment in any court of law. And also, Article 121 of the Constitution, it clearly stipulates that the Parliament of India cannot discuss the statement of a judge in the legislature. So, in the no discussion can take place on the actions or on the statements that is given by the judiciary or by judges. And similarly, the Supreme Court or the intervene in case of any statement or any speech or any act that has been done in the floor of the parliament. So these two articles, Article 121, which prohibits the Parliament from discussing the conduct or the speeches of the judges, and Article 122, which prohibits the Supreme Court from intervening in speeches given in the Parliament on the floor of the Parliament. So these two articles, it further ensure the executive and the judiciary. In the case of states, it is Article 211 and Article 212. Article 212, it says that the High Court of States, it shall not intervene in case of any speech given on the floor of the state legislature. And Article 211 states clearly stipulates that the state legislature shall not discuss the conduct or action of any judge on the floor of the House. So these four articles, if we say, Article 121, 122, 211 and 212, they further ensure the separation of the executive from the judiciary. And also Article 50 of the Constitution of India, it clearly stipulates, which is a part of the directive principles of state policy, it says that it is the responsibility of the state to ensure separation of the executive and judiciary in the services of the state. So, separation of the executive and the judiciary is also a part of the directive principles of state policy. And of India has been authorized to have its own establishment and over it. So the judiciary in India, it performs the following functions. It is the interpreter of the Constitution, and it interprets the Constitution with due wishes of the framers of the Constitution. It cannot interpret arbitrarily. It has to give due deference to the wishes of the framers of the Constitution of India. And it upholds the federal principle of maintaining balance between various organs of the government and also between center and states. And of course, we have discussed that the Supreme Court is the guardian of the fundamental rights of citizens, and Article 139 gives the Parliament the power to further enlarge the writ jurisdiction of the Supreme Court. The Supreme Court or the judiciary is also entrusted with the responsibility of ensuring constitutional validity of legislative, quasi-legislative, executive or quasi-judicial actions of the states. So this is the power of judicial review. The Supreme Court or the High Courts in states, it can review any law that has been framed by the Parliament or the state legislatures respectively. So the laws that the Parliament or the state legislatures are framing, they have to be in accordance with the Constitution of India. If they violate the Constitution, then the Supreme Court can hold them null and void. So that is why the Supreme Court has been given the power of judicial review, and judicial review has now become a part of the Constitution. In Keshavanand Bharati versus Union of India, the Supreme Court stipulated that judicial review is an essential feature of the basic structure of the Constitution. And also the Supreme Court in Mineral's case, 1980, clearly stipulated that harmony and balance between the fundamental rights and the directive principle, it forms an essential feature of the basic structure of the Constitution of India. The judiciary has also been entrusted with the responsibility of interpreting the laws made by the government, and after interpreting them, after scrutinizing them, to decide, to arrive at a conclusion whether those laws are in accordance with the constitution or not. If the law is of the opinion, if the bench that has been formed, that bench is of the opinion of that the law is not in accordance with the constitution, it violates the constitution, then the judiciary can hold it null and void. Example, 2015, the Supreme Court of India invalidated the uh, the Constitution of India, created the National Judicial Appointments Commission. So the National Judicial Appointments Commission had been created by the Union of India to appoint judges in the Supreme Court and the High Courts, and the Union Minister of Law had also been a part of the National Appointments Commission, along with the Honorable Prime Minister and the other matters. The Supreme Court is the decision of the Supreme Court is final and binding. So we have discussed that the Supreme Court has original jurisdiction, appellate jurisdiction, and also advisory jurisdiction. So the original jurisdiction, it lies in cases of disputes between one or more states, or between the government of India and any state, or states on one side and one or more states on other side, or in case of conflict between two or more states. The Supreme Court also has appellate jurisdiction. So cases, so those who, if the High Court of India, it gives any judgment, the convict or the petitioners, they have the right to appeal to the Supreme Court of India. It is the highest court of appeal, both in case of civil as well as criminal matters. And the jurisdiction of the Supreme Court, it extends to both civil and criminal appeals from the high courts under certification from these courts, or in the absence of the high court, permitted by the Supreme Court itself. So if the Supreme Court thinks that the high courts are overstepping their jurisdiction, the Supreme Court can restrain the high court from doing that, and can transfer the case to itself. All right. So this is also a part of the Supreme Court's writ jurisdiction. As part of the writ of mandamus, the Supreme Court can do this if the Supreme Court thinks that a high court or a subordinate court is overstepping its jurisdiction. The Supreme Court can transfer the case to itself. And normally the appeals to the Supreme Court are in cases which involve substantial questions of law, or regarding interpretation of the Constitution, or death penalty if it has been awarded by a high court. Only in these cases the appeals are accepted in the Supreme Court. Not in any ordinary case, only if the case involves a substantial question of law or interpretation of the Constitution, or regarding death penalty by a high court, awarded by a high court. Only in those cases can an appeal be made to the Supreme Court. And also there is a provision for special leave petition under Article 136. Any person can seek special leave petition by the Supreme Court, and the Supreme Court can grant any person special leave under Article 136 of the Constitution. And finally, as we had discussed, that the Supreme Court also has advisory jurisdiction, that is, the President of India has been vested with the right to seek to the prevention of sexual harassment of women at workplace. Uh, in issuing the Vishaka guidelines in 1997, after the Bhavri Devi case, Supreme Court of India, it referred to the Universal Declaration of Human Rights. The Supreme Court of India referred to the Universal Declaration of Human Rights in giving its judgment in the Vishaka guidelines. So the Supreme Court of India not only refers, while giving its judgments, it not only refers to the Constitution of India or to the Indian Penal Code and Criminal Procedure Code. Rather, it can also give reference of the agreements and the treaties that the government of India has ratified at the international level as well, to determine the normative validity of the law as well. Not only to ascertain that whether procedures have been followed, but also to check if that law is not arbitrary. Okay. Also to check if that law is not violative of basic human rights. So the power of judicial review of the Supreme Court is very broad, and there are specific articles also in the Constitution of India which guarantee judicial review of legislation. Article 13 of the Constitution, it says that any law that is being made by the legislature cannot be violative of the fundamental rights. And Article 32 we have already discussed, that is right to constitutional remedies. So these various articles in the Constitution, they give the power of judicial review to the Supreme Court of India and also to the High Courts. So the scope of writ jurisdiction of the High Courts is much broader than that of the Supreme Courts. In case of the High Courts, they can also intervene if the legal rights of the citizens have been violated. However, the Supreme Court can only intervene if fundamental rights have been violated. So judicial activism is another very important thing. It is the use of judicial power to articulate and enforce counter ideologies which, when effective, they initiate significant recodification of power relations within the institutions of governance. So the justification for judicial activism, it comes from the near collapse of responsible government and the pressures on the judiciary to step in and respond and make policy judgments. So when the elected government, when the executive and the legislature, they fail to articulate policies or they fail to uphold law and order, it is the judiciary that intervenes. So only in cases where the elected government or the executive and the legislature have failed to perform their duties, only then the judiciary can step in and can perform the role of the legislature or of the executive. So the terms judicial activism and judicial restraint, they are used to describe the assertiveness of judicial power. So judicial activism is exercised only when political organs of the state fail to discharge their constitutional obligations effectively or remain indifferent to the values of social and economic justice. So it is only then that the Supreme Court has to fill in the void, has to step in and assume the role of a policymaker and legislator as well, and to monitor and oversee the implementation of its directions. So in that case, the Supreme Court can also perform executive and legislative functions. So the definition of the state given in Article 12 of the Constitution, in many cases, it also includes the judiciary as well. It not only includes the executive and the legislature, but in cases where the executive and the legislature have not been able to discharge their functions properly, when they have failed to effectively perform their constitutional obligations, the judiciary is forced to intervene, either on its own, or if some citizen files a petition in the judiciary, then the judiciary is forced to intervene to uphold social and economic justice. So the judiciary also becomes a part of the state then under Article 12 of the Constitution. So in such cases, the apex court, the Supreme Court, or at the provincial level, the high courts, they transcend from being an interpreter of the law to being a lawmaker. So I've already discussed the various reasons for the growth of judicial activism. One of them is failure of responsible government, and the other being the violation of fundamental rights of the citizens and the failure of the government to uphold and protect the fundamental rights of its citizens. And also, in order to usher in social reform and change, if the judiciary thinks that the political executive is not being able to effectively usher in, not being able to effectively implement social reforms, the judiciary can step in. And the Constitution also gives the power to the judiciary to intervene. So the judiciary can intervene through the concept of public interest litigation, which I had discussed in the public interest litigation is also called the social action litigation. I had discussed it in the beginning of the class. Is that when fundamental rights of the citizens are being violated, if those citizens themselves are not able to approach the Supreme Court, any public spirited individual can approach the Supreme Court, or in case of legal rights are being violated, they can approach the high courts as well in order to restore those rights. So the concept of locus standi, which stipulated that only those whose rights are being violated, only they can approach the judiciary, that has been set aside by the Supreme Court in the Roshanara Khatun versus State of Bihar, which concerned the situation of under trials in the jails of Bihar, and also in the MC Mehta versus Union of India case 1986. In these two landmark cases, the Supreme Court of India, it set aside the principle of locus standi, and it recognized that not only the standing of the aggrieved person, but also the public spirited individuals and institutions can play an active role in enforcing the rights of the unrepresented sections of the society, or the deprived and backward sections of the society. In order to enforce their fundamental rights, any public spirited individual or institution can intervene on their behalf. So the scope of public interest litigation is also there. However, there have been allegations on the Supreme Court that in the name of judicial activism, it is indulging in judicial overreach. It is breaching its jurisdiction, and it is interfering too much in the functioning of the legislature and the executive. Hence, it has been advised by many legal luminaries that the judiciary should practice judicial restraint. It should intervene only in those cases where it is extremely necessary, where there is no other option. It should not intervene. It should not be the norm. Rather, it should be the exception. Judicial intervention should not be the norm. Rather, it should be the exception. So, the concept of judicial restraint also comes into being here. So, the public interest of litigation that we have just discussed, it has essentially constituted a cooperative and collaborative effort on the part of the petitioner, which can be the state or the public authority and the court. So that has played PILs, or which are also called social action litigation. They have played a very important role in enabling the deprived sections of the society to get social justice. And since the growth of judicial public interest litigation, we have seen that there has been a resurgence of judicial activism through the public interest litigation, and it has also played a very significant role in keeping a check on executive arbitrariness. All right. So, in also the public interest litigation or social action litigation, which was initiated by Justice P.N. Bhagwati, who was a judge of the Supreme Court of India, also became the Chief Justice. So he initiated it. It has played an important role in ensuring that the administrators are accountable to the people, that there is a rule of law in all spheres of public life. So that is why the scope of PIL has become very expansive. And through the public interest litigation, the Supreme Court of India has broadened the definition of the fundamental rights. For example, if we take the Article 21 in the Constitution of India, which is related to the right to life and personal liberty, the Supreme Court has broadened its definition to not only include right to life and personal liberty, but also right to life with dignity, right to a clean environment, to a clean air, also right to privacy in K.S. Puttaswamy versus Union of India case 2017. The Supreme Court also included the right to privacy in the right to life and personal liberty. In the M.C. Mehta versus Union of India case 1986, the Supreme Court also included the right to have a clean environment as part of right to life and personal liberty. So the scope of the right to life and personal liberty is being broadened by the Supreme Court through the social action litigation or public interest litigation. So we are done with the second block of our paper, that is administration at the union level. And now let us discuss a little bit about the next block. We have done the first two blocks so far. In the second block, we discuss the executive, legislature, and the judiciary. Now, in the block 3, we are going to discuss the institutional frameworks at the union level. The institutional framework at the union level. And in this, we are going to discuss 4 units, beginning with the Cabinet Secretariat. After that, we are going to discuss the Central Secretariat, the All India and Central Services, and finally, the administrative tribunals, which have been created under Article 323A by the 42nd Amendment. So let us begin with Unit 6, that is Cabinet Secretariat. So Cabinet Secretariat, if you see, it is a British legacy to India. The basic duty of the Cabinet Secretariat is to maintain records and provide secretarial assistance to the Union Cabinet. So before 1935, before the Government of India Act 1935 came into being, the Governor General of India had a private secretary, and that private secretary provided secretarial assistance to him as well as to the Executive Council of the Governor General. So Lord Wellington, Governor General between 1931 and 1936, he used to have a private secretary attend meetings of cabinet and also record the proceedings. So in pre-independence India, Sir Eric Coates was the first cabinet secretary. However, his designation was not that of cabinet secretary. Rather, he was the secretary to the Viceroy's Executive Council, which existed at that time. Now, if we see the Cabinet Secretariat, it has 3 wings: the civil wing, the military wing, and the intelligence wing. Now, these three wings, the cabinet secretariat is composed of these three significant wings. The first one being the civil wing, the second being the military wing, and the third wing being the intelligence wing. Now, the civil wing, it provides advice and assistance to the Union Cabinet. The function of the civil wing is to provide advice and assistance to the Union Cabinet. The military wing provides secretarial assistance to the Defense Committee of the Cabinet and the Military Affairs Committee, the National Defense Council, and other committees dealing with the defense matters. While the civil wing, it provides advice and assistance to the Union Cabinet, the military wing, which is the second wing of the Cabinet Secretariat, it provides secretarial assistance to the Defense Committee of the Cabinet, to the Military Affairs Committee, to the National Defense Council, and other committees which deal with defense matters. The intelligence wing, it deals with matters pertaining to the Joint Intelligence Committee of the Union Cabinet. So besides the cabinet secretariat has following organizations. So besides having the civil wing, the military wing, and the intelligence wing, these three wings that are there, the cabinet secretariat also has certain other organizations as well, which are as follows. The research and analysis wing, also called the RAW, the Director General of Security, the Special Protection Group or the SPG, the Joint Intelligence Committee, the Directorate of Public Grievances, the National Authority, Chemical Weapons Convention. So besides these six which we have discussed, there are a large number of other secretaries and officials as well, like Under Secretary, Deputy Secretary, and in addition, the Cabinet Secretariat has subject-related advisors to the Prime Minister of India. So, not only has it got the civil wing, whose task is to provide advice and assistance to the Union Cabinet, it also got the military wing, which provides secretarial assistance to the on defense matters to the Defense Committee, to the Military Affairs Committee. Also got the intelligence wing as well. And apart from these three, it has also got these six organizations: the RAW, Research and Analysis Wing, Director General of Security, the Special Protection Group, the Joint Intelligence Committee and Directorate of Public Grievances, and the National Authority on Chemical Weapons Convention. So these are some of the components of the Cabinet Secretariat, which we are going to discuss in detail in the next class. So in this class, we have discussed the role of the judiciary, the Supreme Court and the High Court, their writ jurisdictions, their functions, their responsibilities, the concept of judicial activism we have discussed. We have also discussed the concept of public interest litigation, and we are going to continue with this unit in the next class. Thank you.